The minority leader is recognized. You may proceed, sir.
So thank you, Mr. President, for giving me your permission to make this manifestation on the topic touched earlier by our majority leader, Mr. President. This is the issue of whether the impeachment complaint transmitted by the House of Representatives to this Senate last February 5, 2025 can cross over to the Senate of the 20th Congress. Well, Mr. President and my dear colleagues, doubts have been publicly expressed by certain personalities whether the trial of the impeachment complaint against the Vice President can continue or cross over into the 20th Congress. I wish to share and put on the record some of my thoughts on this particular issue. Article 11, Section 3, Paragraph 6 of the Philippine Constitution provides that, and I quote, "The Senate shall have the sole power to try and decide all cases of impeachment." Hence, this provision makes the Senate not just an impeachment court, but the impeachment court. An impeachment proceeding is sui generis, that is, unique or a class of its own. In Republic versus Sereno, it is described as a proceeding exercised by the legislative as representatives of the sovereign to vindicate the breach of the trust reposed by the people in the hands of the public officer by determining the public officer's fitness to stay in office. While the form, procedure, and substantive arguments in impeachments remind us of a court trial, it also has the characteristics of a political process. The decision-making process in impeachment is not governed by any fixed or binding standard of proof, allowing for broad discretion on the part of the members of the impeachment court when they make their final decision on the case. The decision makers or the members of the impeachment court can use any standard of proof they want, and this choice will not be subject to any review by any court except the court of public opinion, which is not technically a court. This fact gives the impeachment proceedings its political character. Hence, to better understand these sui generis impeachment proceedings, we need to look for analogies using well-known principles and practices in other systems which are applicable to impeachment proceedings. As to the question of whether the impeachment trial conducted by the Senate in the 19th Congress or the impeachment complaint entertained by the Senate in the 19th Congress can cross over and continue into the 20th Congress, there is no provision in the 1987 Constitution or in the Senate Rules of Procedure on impeachment trials that expressly prohibits this. On the contrary, the Senate Rules on Impeachment support the position that the impeachment trial shall continue until final judgment, even if it is necessary to continue into the next Congress. Let me read the rules. Rule number 3. Upon presentation of the articles to the Senate shall specify the date and time for the consideration of such articles. Unless the Senate provides otherwise, it shall continue in session from day to day, except Saturdays, Sundays, and non-working holidays, until final judgment shall be rendered, and so much longer as may in its judgment be necessary. There is a contrary opinion that the rules of the Senate mandate that all pending matters and proceedings shall terminate upon the expiration of one Congress should take precedence over the cited rules on impeachment. which state that the trial shall continue until final judgment. The justification for the precedence given to the rules of the Senate is that the latter were passed by virtue of the power granted by the Constitution to the Senate to promulgate its rules. That is found in Article 6, Section 16, Paragraph 3, which provides each House may determine the rules of its proceedings. However, the Senate rules on impeachment were also passed by virtue of the power granted by the same Constitution to the Senate to promulgate its rules on impeachment. So, let us all look at Article 11, Section 3, Paragraph 8, which provides the Congress shall promulgate its rules on impeachment to effectively carry out the purpose of this section. In fact, there should be no conflict between the two rules because the rules of the Senate apply to legislative proceedings of the Senate, while the rules on impeachment apply to cases of impeachment. On this issue, the Supreme Court in the case of Pimentel Jr. versus Joint Committee of Congress ruled that the legislative functions of the 12th Congress may have come to a close upon the final adjournment of its regular sessions on June 11, 2004. But this does not affect its non-legislative functions. Conducting impeachment trials is most definitely not a legislative function. In fact, the section in the Constitution which speaks of impeachment is found in Article 11 under the title Accountability of Public Officers, and not under Article 6, which is titled the Legislative Department. The conduct of impeachment trials, therefore, should not be affected by the final adjournment of the legislative session. Furthermore, we can use the analogy of the court system. Under the 1987 Constitution, the Senate is the impeachment court. The Senate in impeachment cases is more like a judicial body than a legislative one. Just like a court, the workload, caseload, or docket of the Senate as the impeachment court will not and should not be affected by a change in membership. We can see this principle in action in all our courts and electoral tribunals, where their case dockets do not change and are not reduced or reset to zero whenever there are changes in the court's membership. Likewise, it is well settled that jurisdiction once acquired is not lost but continues until the case is terminated, and hopefully terminated to its logical end. Hence, it is my humble opinion that the trial of the current impeachment case, now pending before the Senate of the 19th Congress, can cross over or continue from the 19th Congress to the 20th Congress. The impeachment docket of the Senate Impeachment Court continues and remains to be the same. So thank you very much, Mr. President, my dear colleagues, for your time and attention.
Thank you, Senator Coco Pimentel, our distinguished Minority Floor Leader.
Although that was only a manifestation, I am willing to entertain questions. Should there be any questions, Mr. President?
Just two quick questions with the permission of this body.
With the permission of the Honorable Pimentel, the gentleman may proceed.
Mr. President, kanina po narinig ko yung historical antecedents ng binanggit, Your Honor, Senator Pimentel. Would the good gentleman agree that the reason why the position of constitutionalists, textualists for that matter, on this issue is that the Constitution,
Russian tabloid news, kumikiling sa katotohanan. Balita serbisyo, walang iwanan. Dinig na sa laging handa sa